It's a rare case where you're able to go to the Supreme Court and say, what's at stake here is one of the principles that actually animated the American Revolution. The colonists and the founders were appalled at the notion that people's private cabinets and homes and offices could be subject to rummaging expeditions by colonial officers. And so that is the animating force behind the Fourth Amendment. The Fourth Amendment to the Constitution says that the government cannot engage in unreasonable searches or seizures. And so generally what that means is it protects our privacy and our home, our physical items over the course of history. Fast forward 200 years, we asked the Supreme Court to say those protections shouldn't be any different simply because all of our most private papers now are kept on a device that we can carry in our pocket or our purse or our briefcase. David Riley was a junior college student in San Diego who was driving home from classes one morning and pulled over for having expired tags. During the course of that traffic stop, the police discovered firearms in his car, which he didn't have permission to be carrying. So he was arrested for illegal possession of those firearms. And at that point, they did the traditional pat down of the arrestee and found his smartphone. And both at the scene and then later at the station house, engaged in a full search of every digital piece of information on a smartphone. So this particular issue in the Riley case was whether the Fourth Amendment allows the police to engage in a search of a person's smartphone without first procuring a warrant. The primary point that we made in the brief was that old protections shouldn't fall away simply because our most private information is kept in new form. That the police should have to go first try and get a warrant before they search through the digital contents of a smartphone. After the government filed its brief, where it expressed concern that if they weren't able to search smartphones and laptops and iPads seized right away, the information could be wiped remotely or encrypted and therefore kept from the government in perpetuity. We went on eBay and got a replica of our client's phone, and the student basically took it apart and put it back together and was able to explain by doing that the way the information is stored, the way the police could protect information in a phone without having to search it right away in order to go get a warrant. So these technological issues were just as important to our legal argument as history and constitutional precedent. Well, the decision is important because the Supreme Court recognizes in the opinion, unanimously, that digital is different than physical. In other words, just because we might be able to sort through somebody's luggage doesn't mean that we can open up their laptop and search through all the files. The Riley decision is already having a big impact. In courtrooms across the country, people are now citing it every day. Judges are referring to it and they're arguing about what exactly it means, but the court has clearly told people that issues about digital privacy have to be addressed on their own terms. It's no longer sufficient after Riley for the government to come in and say, in the old physical world, in the analog world, we are allowed to do ABC, so we can treat digital information no different. Riley takes that argument off the table and says physical information is different than digital information, and digital information is entitled to special privacy protections.